Hey, so this is a little share that relates to a previous discussion we had regarding staying within the procedures and processes of the SSA when you want to get something accomplished and you don't want your matter to be closed without an ability to do anything to reverse what happened. And the inability can come to be a permanent inability to address if we fail to take the steps necessary to exhaust the administrative remedies. So it just came up again where this is the pro bono case I have where the individual has an overpayment and it was argued against because we don't think there was one at all. It was a misunderstanding by the SSA. And they have since decided that she's no longer working 2 jobs. She never was. It was all a misunderstanding of documents. So there had been a recon appeal of that non-medical determination. And then the person had spoken to the local field office and someone had looked at it, which was very kind because often they won't do that if it's not their case to be handling, and said, oh, I see what happened here. Yeah, this should be remedied super easy. Well, lo and behold, did another determination that says the exact same thing. That, yeah, I know that overpayment from before still stands. Makes 0 sense. But anyway, it makes 0 sense. So it's really frustrating. We are really hoping that that would have just resolved it. All the evidence had been put in. We don't even know what's in dispute because they don't tell you in these things. And I know that's very frustrating to many of you when you don't get the explanation, just the determination of slap down. So now we have to appeal for an ALJ hearing. Unlike many an overpayment situation, I don't think it's going to be as voluminous of a work contribution. We don't have to go through 10 years of every month of income and expenses and all this other thing because it's very unrelated to that. So that's a good thing. And I would imagine that this person would have to prevail, but you know, there's no guarantees except that I know that the judges actually think about things as opposed to the rubber stamp sometimes clerkies in the local office do. So, but to drive home the point, even though even a person at the field office says, oh, this looks super simple, I don't think this is going to be a problem. Well, they weren't the decision maker apparently. And it got rubber stamped as you still have an overpayment despite the stuff that you provided. And we're not explaining to you why you still have it. We're just saying that you do. Your remedy is to appeal within 60 days, blah, 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 blah. So guess what we're doing in the next couple of weeks? We are appealing for ALJ hearing, blah, 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 blah. Because that is, it says it right in the letter. You have to read your letters. If we don't do that, it is done. It will become finale. Okay. So when we think, well, why can't they just overturn it? Because it's ridiculous and and this would just save everybody more time, including a judge and all his staff, and tons of hours of labor. And I get that. I totally get that. But everything has to go down its little course. So when the whole purpose of that appeal is to correct someone else's error. So technically, this is what would happen, an appeal anyway. It's not like you can just, go to your manager at work when something went wrong and say, hey, we need to take a look at this, fix it. When things are in the government purview, I guess, because you have due process rights differently than if you're in a private sector, things have to go down these little channels. And when someone gives a bad decision here, you have to exhaust the remedy in the fashion that it's designed, right? The due process, and the appeals are due process. So very, very important to always follow the due process steps and don't think that you're going to make the rules as to how they are effectuated. Okay. So we will have our chance before an administrative law judge eventually. I imagine it'll be several months away. Hopefully there will be no overpayment of $25,000 or so, and all will be fine for this person going forward, and they don't have that hanging over their head or paying it when they shouldn't be. So anyway, one of the little pro bonos I do, I don't typically choose to take overpayments, but this one seemed very cut and dry without me putting in 2 years and 2,000 hours of work, which I don't have spare time for. So, so don't be calling me with overpayment request, pro bono representation. In fact, I did represent initially, and I'm technically not on board yet. But when I file the appeal, I will come on board because I think it will be doable, and it will just help her not have to deal with it herself. Some people just won't. They'll just drop the ball, you know, because they're like, no, this is too stressful. I don't want to do it. I'm just going to eat it. And that's not right. So anyway, I am doing it. But again, this is not something that I would normally be doing. But because it's very cut and dry, it's not a million pieces of paper that I have to go find and then sort through and then put into charts and do all this other stuff. So, but it's all about following the process, the branch of exhausting those appeals and anything else in that letter. Whatever letters you get, you've got to read them. I would highlight the parts that say you can do this. I mean, you need to know it because if you violate a date, you lose. Okay. And you generally lose forever. As a general rule, not always. All right. Take care now, guys. Bye.